Welcome, Employment Law Show. John Scholes, Lior Samfiru, reaching out anytime. 1-855-821-5900, employmentlawyer.ca, the firm website, and you want to go to pocketemploymentlawyer.ca. Anytime. That is a wealth of information when it comes to your rights in employment law, and inside there as well is the severance pay calculator. Literally hundreds of thousands of people have used this thing. If you haven't tried it, if just only for the exercise, give it a shot. See how much severance you will really be owed. Coming up today, we will get to lost your job due to COVID-19. You will find out what non-union employees, what it means to them. We'll get to that and a couple references to the Pocket Employment Lawyer, of course, Lior. But first, the week that was. How are you, pal?
Hey, John, I am doing great, and I am ready to go here to talk more about employment law, as we do every week. You know, I've had so many people email me or call me and say they watched the show, or they watched afterwards on YouTube the clips that we put on, and they've learned something, and that they made them realize that there's rights that they didn't otherwise know that they had. Well, that's exactly why we're here. That's why I'm so proud of this show, the only show of its kind in Canada, because we educate individuals about workplace rights. We tell you what the law is. We don't lecture you about this section or that section. We simply tell you what you need to know. If you're working, if you lost your job, if things don't work out or are not working properly in your job, well, what to do, how to respond, what your rights are, what your employer can and cannot do. We all have questions like that. I know that before I became a lawyer, I had tons of questions about these issues. Well, if you have questions about your job, your rights, someone else's rights, well, listen in. We're going to talk about so many things on the show today, like we do every week. And of course, if you don't get your question answered or you want to talk to me privately, please don't be bashful. I'm not going anywhere. You can reach out to me on email. You can reach out to me by phone. We can connect and discuss those issues. We'll give you that contact information throughout the show. Very easy to do. So there's always solutions to whatever workplace problem you are facing. But like I do every week, I like to start off with a case. Week that was, situation that came across my desk very recently. I spoke with a gentleman who recently was diagnosed with a sleeping disorder, quite severe. Now, to make things worse, this person actually was working night shifts. And his doctor felt that working overnight made his condition much worse, that he needed to have a consistent shift, by the way, whether it's day or night, but it has to be consistent, as opposed to a few days on, a few days for night, a few days during the day, because that really threw his sleeping cycles off and made his condition much, much worse. So he provided a doctor's note to his employer saying, I need to be on consistent shifts, whether it's days or nights, doesn't matter to me, but I have to be on consistent shifts. And that note was very clear that for medical reasons that's necessary, at least for a period of a few months, to see how things go. Well, his employer was very adamant that no, we cannot do that. No one else is in that situation. Imagine what would happen if we let you do that. Everyone else would want to do that. Everyone else has to change shifts based on the schedule that we post. We can't just make an exception for you. So sorry, we're not going to do that. If you need to be off work because you're not feeling well, fine, you can take a medical leave, but we're not going to change the shifts for you. And of course, very upset, this gentleman called me and he wanted to know, is his employer doing something wrong by refusing to accommodate him? Well, the answer is a resounding yes. The employer is absolutely doing something wrong. And this concept of the duty to accommodate, hopefully most of our regular viewers know about this, but that's the idea that an employer has to provide assistance and support and even changes to the workplace if there is a legitimate medical reason. In this case, there was. It was corroborated by a doctor who even said, here's what needs to be done to fix it. His employer could have done it, chose not to do it for reasons that ultimately don't matter. It doesn't matter if it causes you a bit of a headache or if other employees complain. The law says you have to accommodate, even if it's not easy. In fact, even if it's quite difficult, you have to provide that accommodation. And if you don't, that's a human rights violation. I'm going to be involved now. I'm going to help this person. I'm going to remind very nicely his employer of its legal obligations, and I expect that the employer, once it hears from me, will do what it's legally required to do. But I wanted to remind everyone here, whether it's COVID-19 related or completely unrelated to it, if you have a medical condition that requires help or support, accommodation from your employer has to provide that accommodation. If they don't, that's illegal. That's not something your employer can choose to ignore. Our laws are very clear. In fact, it's one of the most basic and important legal rights that we all have. It's that duty to accommodate.
What if the employer starts snooping around saying, yeah, okay, maybe, but what's wrong with you? We want to know what's wrong with you.
You know, that happens so often, actually, a lot more often than it should. And the reason I chuckled is because an employer is not allowed to ask those questions. It doesn't ultimately matter what the medical condition is. You may suffer from depression, you may have a herniated disc, or you may have cancer. Whatever the condition is, ultimately doesn't matter. What matters is, number one, can you or can you not work? Number two, do you need accommodation and what that accommodation is? And finally, number three, does your doctor support you? As long as your doctor supports you, have a medical condition that can be accommodated, the employer has to accommodate. They cannot ask you personal, private questions. It doesn't matter. You cannot be punished for refusing to answer, but your employer has to accommodate, but get that doctor's note.
EmploymentLawyer.ca is the website for more information about that, and to catch our radio show across the country, you can find a station that carries it. We play the phone calls from the radio show on this show for TV, and we listen to them and talk about them. First call of the day is coming up now.
I have worked for a federally regulated transportation company, 2 years less a week. I've been off on sick leave since May 15th of 2020 until current. Just received notice of termination, which kind of sucks being terminated while you're off on sick leave, but hey, it happens, I guess. What they've offered me is 2 weeks. Does the vacation still accrue while you're off on sick leave?
So there's a number of things that I need to break down here, and this is a good example of someone asking the wrong question. So he's asking me about, does his vacation accrue when he's owed months' pay by way of severance? So in terms of vacation pay is a function of income that you earn. It's a percentage of your income. So if you're not earning income, you're not accruing vacation pay. But the real issue here is severance. Now, we know that this person worked for a federally regulated transportation company. Well, very important to remember, for everyone out there that's federally regulated, it doesn't matter if you're federally or provincially regulated when it comes to your severance. Your full termination and severance entitlements, what we call your common law entitlements, are the same whether you're provincial or federal. And they're based on your age, your position, and the length of your employment. Now, one of the other issues here is, depending on why he was let go, it could be a human rights violation. If he has a serious medical condition or a disability and he was fired because of that, then that's illegal. You cannot be let go because you have a disability, because you have a serious medical condition. Again, that's a human rights violation. But even on the severance front, again, he wasn't calling us about that, but let's tell him what he is owed. And for me to do that, let's just go to pocketemploymentlawyer.ca. Let's plug in the information so that we can all see what this person is owed. So we know this person is he's older. I picked an age, let's say 73. He's in transportation. He worked for his employer for 2 years, and he was paid 2 weeks' pay. Well, John, as you see, Pocket Employment Lawyer correctly determines and assesses him as being owed 5 months' pay. 5 months. So he was calling about, do I get a couple $100 in vacation pay, when in fact he's owed about 5 months' pay. PocketEmploymentLawyer.ca is the tool that we use to find that out. And again, even only 2 years of employment. Most people would say maybe he gets 2 weeks, 3 weeks, maybe 4 weeks if he's really, really lucky. No. 5 months' pay is what he's actually owed. You don't believe me that that's the case? Check it out for yourself at PocketEmploymentLawyer.ca.
Another place for you to go to ask questions anytime, terminationquestions.com. Go there again, terminationquestions.com. We'll get to our first one today, Lior. This one from Ajit. Ajit says, I rely on a bonus for nearly a third of my salary, which I've consistently achieved every year. Our company, which has seen strong profits despite the pandemic, is now eliminating the bonus for the year. Is that legal? It's Clark Griswold. No pool.
Hopefully he hasn't put in a pool. It's also not the Jelly of the Month Club.
No.
But beyond that, in all seriousness, a bonus becomes an important component of compensation for many people. And a bonus becomes a regular component of compensation if you get it regularly. So every year you get a bonus. I mean, we're laughing here about the Clark Griswold situation, but for those who have seen the movie, Clark Griswold gets a bonus every year. He knows right around the holidays, he even knows approximately the dollar amount. Well, that becomes a regular term of his employment. Same with you. If you get a job where it has a bonus that's paid regularly, the amount may not be exactly the same, but you know you're getting it beginning of the year or end of the year. Well, if the company decides to take it away for whatever reason, well, unfortunately, that's now a reduction in pay, which results in what we call a constructive dismissal. Just like a company can't reduce your salary, they can't take your bonus away. because your bonus is part of your compensation. Now, if it's one of those bonuses that some years you get it, some years you don't, and that's the reality, then fine, they can do that because clearly it wasn't a regular component of your compensation. But if you always get the bonus, if it's a regular component of compensation, it cannot be taken away. And if your employer takes it away, as usual, you have the choice. The choice is you can accept it and continue working, and now your new reality is no bonus, or you can choose to treat that as a termination of your employment, constructive dismissal, and get your full severance. That's the reality whenever your bonus gets eliminated.
What if it's a case where you're let go just before they give the bonuses out? You think, oh, well, I missed the boat on that one. Not necessarily, right?
Now, we talked on a recent show about the fact that that's not something an employer can do legally. Your employer cannot choose a convenient termination date in order to avoid paying you a bonus that you're legally owed. In fact, if they do that, not only will they have to pay the bonus, they may have to pay additional damages because of their bad faith conduct. So no, an employer cannot avoid its obligations by choosing a date.
Coming up here, facts for non-unionized employees who have lost their gigs due to COVID-19. But first, we'll take a break. In the meantime, 1-855-821-5900, help@employmentlawyer.ca to reach out through email as well. We'll continue Employment Law Show. Lots more is on the way.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurance to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. It's John Scholes and Lior Samfiru. So you've lost your job due to COVID-19 and you are a non-unionized employee. Here what you need to know. Why, first of all, before we get into these points, Lior, non-unionized, unionized, why does that matter?
So very important. In fact, it's something you keep in mind that whatever we talk on the show, this TV show, our radio shows, really only applies to non-union employees. The rules, the laws for unionized employees are different. They're all really in the collective agreement. And the only one that's allowed to help a unionized employee, is the union. You can't hire me. You can't hire another lawyer. If you're part of a union, the union has to help you. They're only ones allowed to help you, and the laws are different. So whatever we talk about on the show, you can always assure yourself that it really only applies to those employees that are not part of a union.
Fact number one for those non-unionized employees, you do not have to sign termination papers or a severance offer right there on the spot or by the written deadline.
I actually had this week alone 2 people contact me after they signed. They signed it on the spot because their employer said, well, legally you have to sign.
Right.
Well, but what does that mean? Think about it. Does that mean that if you don't sign, the police is going to wait outside the door and arrest you because you didn't sign? No, it's nonsense. It's a pressure tactic. That's all it is. And oftentimes you'll see a termination letter that has a deadline. A severance letter has a deadline. You have to sign this now, or you have to sign this tomorrow or Friday. And that's all that is a pressure tactic. It's intended to make you feel like you will lose something if you don't sign. Don't fall for it. You're owed, in most cases, over 90% of cases, a lot more than what you've been offered. So think about it. You're accepting less than what you're offered, and you're doing that really for no reason. So you do not have to sign off on the termination letter. You have as much as 2 years to pursue your termination entitlements. So be smart about it. Don't call me, please, after you sign it because I can't help you. There's no really any reason for you to sign it. And by the way, an employer that's going to put pressure on you to sign it, I can almost guarantee you that employer is doing something wrong.
Second fact for non-unionized employees you need to know, the severance is based on many factors and can add up to 24 months worth of pay, right?
Absolutely. Severance could be as much as 24 months. In fact, in some extreme cases, it could be more than that. And usually severance starts for most people at 2 months' pay. It's rare that anyone gets less than 2 months, even you short service employees, all right? And the main factors we talked about that are your age, your position, and the length of your employment. But there's other factors too. Whether you've been recruited from another job is a factor. The state of the economy is the factor. The industry you work in, your medical condition, the availability of jobs, whether you signed a non-compete, all those are factors, all right? And they could drive your severance up even more than it otherwise is. That's why it's so important to get legal advice if you lose your job, because the factors are there and you may not be able to assess them on your own. It's not a one-size-fits-all. You can't compare your severance to that of someone else's, your brother, your friends, your coworkers. You may be owed more, you may be owed less. But that's why we created pocketemploymentlawyer.ca. That's why I encourage you to call me, so that you know what you're owed, you get that information, and don't accept less than what you're actually owed.
Number 3 is this: you're entitled to full severance pay even if your termination is due to COVID-19. A lot of employers are going to try that, right?
Absolutely. And in a way, you may think, well, this is a once-in-a-lifetime event, this COVID-19, so that must mean that there's special rules when it comes to my severance. Well, there aren't any. Even though this is a unique situation, hopefully one that we won't have to face again in our lifetime, the laws are the same in terms of severance, in terms of what you're owed, in terms of how it's calculated. So there's no new rules. And by the way, even with temporary layoffs, if you've been laid off temporarily, the same rules apply. You cannot be laid off temporarily, even if it's because of COVID-19. You can treat that as a termination. An employer doesn't get to save money to pay less severance just because of COVID-19, even if it's legitimate that they have a financial need. The law is the law, and the law says if you're going to employ employees in this province, in this country, you have to comply with the law. You can't avoid it just because it's difficult.
Talking about the facts, if you're a non-unionized employee, you need to know this next one, really important. Do not accept a termination for cause at face value. What do you mean by that?
So termination for cause, as our regular viewers know, is a situation where the company decides to let you go for something bad that you did, and in that situation, they pay no severance. Well, a termination for cause can only happen if you did something terrible. The fact that you may have screwed up, the fact that you may have made a mistake, does not mean that it rises all the way to the level of cause. Cause is very difficult to establish. It's reserved for the worst offenders. So just because the company says, okay, we're letting you go for cause, look at all these things that you've done, so we're not going to pay you severance, please don't take that at face value. In fact, you may be owed full severance. There's no such thing as almost cause. So if whatever you did doesn't rise all the way to the level of cause, even if it's close but it's not quite there, you still are owed severance. And by the way, we've been talking about pocketemploymentlawyer.ca. One of the tools there is a tool that allows you to find out if, in fact, there is cause. So if something happened and you lost your job for cause, if you go to pocketemploymentlawyer.ca, you'll see our For Cause tool that allows you to find out in your situation if whatever you did, whatever happened, is that in fact cause, or are you owed your full severance?
This next one may shock a lot of viewers, Lior, and that is contractors are often owed a severance package.
In fact, I should have said contractors are almost always owed severance, and that's because most contractors are really misclassified. There really are employees that are called something else. And if you've been misclassified, you're an employee, meaning you're owed your severance like an employee. You may have been believing for years that you're a contractor. You sign a piece of paper that says you're a contractor. Maybe you've incorporated. Maybe you charge taxes and you pay your own taxes to the government. Well, it doesn't matter. If you have a regular job, if you work for a company that tells you what to do, you respond to them and are responsible to them, you are an employee regardless of what you call yourself, meaning you're owed vacation pay, you're owed overtime pay, you're owed holiday pay, but you're also owed severance if you are let go. By the way, again, pocketemploymentlawyer.ca has a tool that allows you to find out if you're an employee or an independent contractor. And it gets even more than that in the sense that even people that are truly contractors may be owed severance. If you are what we call a dependent contractor, you do most of your work for one company, even though you may work for more than one company, but one company is your big client, you get 50% or so or more of your income from that company. If they let you go, they may owe you your full severance as if you are an employee. So calling yourself a contractor or a company treating you like a contractor does not deprive you of your severance, not at all.
All these need-to-know facts for non-unionized employees. Lior, this one's the one we'll wrap it up with. Please, before you sign anything, reach out to an employment lawyer like you to find out what your rights are.
Absolutely. It's always important to do that when an issue comes up before you sign off on anything. I can't really do anything once you've already signed off on it. So I'm available. If you're not sure if you have entitlements, if you're not sure whether or not the law does anything for you in your situation, don't wonder. Don't find out later when it's too late that it did. Just call me right now, email me right now. Let's get that discussion going, because the law will surprise you in terms of how good it actually is.
And the website, employmentlawyer.ca. Go there, as I mentioned earlier on, to find a radio show near you. You can catch our hour-long radio broadcast and the phone calls from it. We play them here. Phone call number 2 is right now.
Is there a maximum notice that a company can give you? Like, if you've been with a company for 18 years, typically you'd be entitled by 18 months. Can they turn around and say, I'm giving you an 18 months notice, or we're going to let you go? And I guess within that notice period, are they still able to terminate you if your performance falls?
Couple good questions.
So we often talk, of course, we've talked 10 times already today about severance and the employer's obligation to pay severance. Well, one way an employer does not actually have to pay severance is if they give the equivalent by way of notice. So if a company owes you 12 months, or in this case, 18 months severance, instead of paying you 18 months severance, they can simply give you 18 months advance notice of the termination of your employment. We call this working notice. They're telling you that 18 months from now you are let go. Now, so long as the company gives you sufficient amount of notice, then they don't have to pay severance. In most cases, a company is not going to give you enough notice, meaning they'll have to make up the difference at the end by way of severance. So yes, you can get notice for your full amount of severance. In most cases, though, companies give less notice than what they're supposed to. While you're working there, during the notice period, the working notice period, the same rules apply. Yes, you can be disciplined if you did something wrong. You can't be let go for no good reason. The company can't change your job or change your compensation. And if you do leave before your last day, that is considered a resignation, and then no other severance would have to be paid.
Coming up here, an abusive working relationship after 22 years. Is quitting an option? We'll talk about that after a break. 1-855-821-5900 and employmentlawyer.ca to reach out.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back. Employment Law Show, employmentlawyer.ca. Yeah, that ad before this was right. That's exactly where you want to go. And while you're there, you can catch our radio broadcast in a station near you. Phone call number 3 coming up for today, Lior, right now.
Temporary laid off. My employer, he's actually asking me to continue contacting clients and keep basically working for the company. Same stuff that I was doing while I was employed. And he's telling me that I have to keep the clients active or else I'm not going to have any clients when I come back to work. Now, I'm not getting paid for this, so this is something that he's just expecting me to do as a personal investment, but I don't want to do it because I'm not working. So we keep kind of getting into this dispute. He's at a point where he's kind of threatening me losing my job.
I want this boss. This guy's awesome.
I mean, this is like a circle. My head almost gets exploded here when I talk about it. Well, let's start with the easy part, which, again, some people may be surprised about, is that regardless of the situation that this person describes, which I'm going to get into in a second, the temporary layoff itself was not legal. He could have chosen this individual to treat the layoff itself as a termination, regardless of what happened afterwards or how the company treated him afterwards. So the temporary layoff for you, for him, could be treated as a termination, and you can get your full severance. But okay, this guy decided not to do that. He wanted to remain an employee and hopefully come back to work at some point. Well, his employer is obviously trying to have it both ways. Well, we're not going to pay you. You're going to be off work, but you're expected to work. And if you don't work without pay, then we're going to let you go. But we really already let you go when we laid you off temporarily. Do you understand now how my head explodes? So, no, you cannot be made to work if you're not getting paid. In fact, it would be illegal for you and for the company to do that. You cannot, an employee cannot work without getting paid. That's a breach of so many laws in whatever province you're working in. It doesn't matter. Illegal. And if you refuse to work while you're not getting paid, you can't be fired for cause for that because you haven't done anything wrong. In fact, you've done the only thing that you could be doing in that situation. So what I would be saying to this person is, no, either treat that as a termination and forget about what this company wants to do, or simply tell them, no, until you call me back and start paying me, I'm not going to work because you're not paying me. Goodbye. You cannot be punished for not working while you're off. You cannot be punished for refusing to work without pay. If that happens, so many laws are being broken. You really have to reach out to me as soon as possible.
And you can do that, by the way, if you see the bottom of the screen or otherwise, 1-855-821-5900. Another way you can reach out, terminationquestions.com. Lior, going to get to another one from that website. Adrian says, the owner has been increasingly screaming and swearing at me these past few months after 22 years of incident-free coexistence. I haven't returned to work after yesterday's outburst, and I don't think I can handle the stress anymore.
So this is obviously a situation that's completely uncomfortable and unacceptable. We all have a right to work in a harassment-free work environment. None of us should be subjected to threats, to abuse, and even to unprofessional conduct. Now, what I want here is this, because if she simply leaves and says, you mistreated me, it's not like the employer is going to admit it. They're not going to say, yes, okay, we did it. So there's got to be a way to document things. So I would want her to start off by sending an email right now to her employer saying, employer, what happened yesterday, unacceptable. This is what you did to me. This is what you said. I don't want to continue working that way, so I'm only going to come back if these things don't happen again. And she does have to go back in that situation, but if she's mistreated again, document it in the same way, and then she may be able to leave and treat that as a constructive dismissal. If you've been being abused or being harassed in the workplace, that is a termination. That is something you can treat as the end of the employment relationship and get severance, but there's got to be a way to prove it. Never assume that the company is going to admit it. It's up to you, the employee, to document this. So start sending emails confirming what happened. Write down what happened, who did what, and on what day. By documenting things, you're going to have a lot more credibility and going to be able to pursue these harassment situations. If there's someone to talk to in the workplace, another boss, an owner, an HR, talk to that person. Follow up with an email so it's documented. But don't ever engage in a situation when there's nothing documented. You can easily document it, so start doing it right now.
Okay, two quick things. What if, number one, the person you're supposed to be, or the one doing the harassing, is the one you're supposed to report to, maybe the top dog, the boss? Number two, what if you don't get any response from your emails?
So if you've tried to deal with it internally, but there's no way to do it because it's the actual owner, the actual boss that's harassing you, have me deal with it. You have to deal with it externally. If you can't deal with it internally, let me deal with it externally, and I'll take care of it. I can get you out of there with compensation. But if you send an email to your boss confirming what happened, you mistreated me yesterday, here's what happened. If the boss doesn't respond, that's fine. Silence is the same as saying yes. No. Silence is the same as agreeing. So you don't need an email from the boss saying, yes, here's what happened, I admit it. Silence is just fine, so don't be afraid to send that email.
Just send them and keep sending them. Make sure you have a record, right? Nice fat record.
If it's not in writing, it doesn't exist. And documenting things always protects you, gives you credibility, makes it easier for you down the road. So you know how in real estate they say location, location, location? For me in employment law, it's document, document, document.
Done for another show. Appreciate it, pal, and I hope you enjoyed it as well. You want to reach out, 1-855-821-5900, the number. Email we use is help@employmentlawyer.ca, and if you want to go there anytime, it's like having a lawyer with you in your pocket at all times, pocketemploymentlawyer.ca. Hope you enjoyed it, and we'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.